Section 12, History, amended HJR 31H, 1982, adopted 1982. Section 13, Habeas Corpus. The writ of habeas corpus shall be grantable of right, free, and without cost. It shall be returnable without delay, and shall never be suspended unless in case of rebellion or invasion. Suspension is essential to public safety. Section 14, Pretrial release and detention. Unless charged with a capital offense or offense punishable by life imprisonment and the proof of guilt is evident or the presumption is great, every person charged with a crime or violation of municipal or county ordinance shall be entitled to pretrial release on reasonable conditions. If no condition of release can reasonably protect the community from risk of physical harm to persons, assure the presence of the accused at a trial, or assure the integrity of the judicial process, the accused may be detained. History. Amendment HJR 43H, 1982, adopted 1982. Section 15. Prosecution for crime, offenses committed by children. A. No person shall be tried of a capital crime without presentment or indictment by a grand jury, or for other felony without such presentment of an indictment or an information under oath filed by the prosecuting officer of the court, except persons on active duty in the militia when tried by court martial. B. When authorized by law, a child as therein defined may be charged with a violation of law as an act of delinquency instead of a crime, and tried without a jury or other requirements applicable to criminal cases. Any child so charged shall, upon demand made as provided by law before a trial in a juvenile proceeding, be tried in an appropriate court as an adult. A child found delinquent shall be disciplined as provided by law. Section 16, Rights of accused and of victims. A. In all criminal prosecutions, the accused shall, upon demand, be informed of the nature and the cause of the accusation, and shall be furnished a copy of all of the charges, and shall have the right to have compulsory process for witnesses, to confront at trial adverse witnesses, to be heard in person by counsel or both, and to have a speedy and public trial by impartial jury in the county where the crime was committed. If the county is not known, the indictment or information may change venue in two or more counties conjunctively, and proof that the crime was committed in that area shall be sufficient. But before pleading, the accused may elect in which of those counties the trial will take place. Venue for prosecution of crimes committed beyond the boundaries of the state shall be fixed by law. B. Victims of crime of their lawful representatives, including the next of kin of homicide victims, are entitled to the right to be informed, to be present, and to be heard when relevant at all crucial stages of criminal proceedings, to the extent that these rights do not interfere with the constitutional rights of the accused. History. Amendment SGR 135, 1987, adopted in 1988. Amendment proposed by the Constitutional Revision Commission. Revision number 13, 1998, filed with the Secretary of State May 5th, 1998, adopted 1998. Section 17, Excessive Punishments. excessive fines, cruel and unusual punishment, attainder, forfeiture of estates, indefinite imprisonment, and unreasonable detention of witnesses are forbidden. The death penalty is an authorized punishment for capital crimes designated by the legislature. The prohibition against cruel and unusual punishment and the prohibition against cruel and unusual punishment shall be construed in conformity with the decision of the United States Supreme Court, which interpret the prohibition against cruel and unusual punishment provided in the Eighth Amendment to the United States Constitution. Any method of execution shall be allowed unless prohibited by the United States Constitution. Methods of execution may be designated by the legislature, and a change in any method of execution may be applied retroactively. The sentence of death shall not be reduced on the basis that the method of execution is invalid. In any case in which an execution method is declared invalid, the death sentence shall remain in force until the sentence can be lawfully executed by any valid method. This section applies retroactively. Ex post facto. Anyway. History. Amendment HJR 3505, 1998, adopted. 1998. Amendment HJR 951, 2001, adopted 2002. Section 18, Administrative Penalties. No administrative agency except the Department of the Military, in an appropriately convened court-martial action as provided by law, shall impose a sentence of imprisonment, nor shall it impose any other penalty except as provided by law. History. Amendment proposed by the Constitution Revision Committee, revision number 13, 1998, filed with the Secretary of State May 5th, 1998, adopted 1998. Section 19, Cost. No person charged with crime shall be compelled to pay costs before a judgment of conviction has become final. Section 20, Treason. Treason against the state shall consist only in levying war against it, adhering to its enemies, or giving them aid and comfort, and no person shall be convicted of treason except on the testimony of two witnesses to the same overt act, or on the confession in open court. Section 21, Access to Courts. The court shall be open to every person for redress of an injury, and justice shall be administered without sale, denial, or delay. Trial by jury. The right of trial by jury shall be secure to all and remain inviolate. The qualifications and the number of jurors, not fewer than 6, shall be fixed by law. Section 23, Right of Privacy. Every natural person has the right to be let alone and free from governmental intrusion into the person's private life, except as otherwise provided herein. This section shall not be construed to limit the public's right to access public records and meetings as provided by law. History. Added CS for HJR 387, 1980, adopted 1980. Amendment proposed by the Constitution Revision Committee, revision number 13, 1998, filed with the Secretary of State May 5th, 1998, adopted 1998. Section 24, Access to public records and meetings. A. Every person has the right to inspect or copy any public record made or received in connection with the official business of any public body, officer, or employee of the state, or persons acting on their behalf, except with respect to the record exempted pursuant to this section or specifically made confidential by this Constitution. This section specifically includes the legislative, executive, and judicial branches of the government and each agency of or department created thereunder, counties, municipalities, and districts, and each constitutional officer, board, and commission or entity created pursuant to the laws of this Constitution. B. All meetings of any collegial public body of the executive branch of the state government or any collegial public body of a county, municipality, school district, or special district at which official acts are to be taken or with which public business of such body is to be transacted or discussed shall be open and notice to the public, and the meetings of the legislature shall be open and noticed as provided in Article 3, Section 4E, except with respect to meetings exemplified pursuant to this section or specifically enclosed by this Constitution. Requirements for subsection A, the exemption of meetings from the requirements of subsection B, provided that such law shall state with specificity the public necessity justifying the exemption and shall be no broader than the necessity to accomplish the stated purpose of the law. The legislature shall enact laws governing the enforcement of this section, including the maintenance, control, destruction, disposal, and disposition of records made public by this section, except that each house of the legislature may adopt rules governing the enforcement of this section in relation to records of the legislative branch. Laws enacted pursuant to this subsection shall contain only exemptions from the requirements of subsection A and B, and the provisions governing the enforcement of this section shall be related to one subject. D. All laws that are in effect on July 1st, 1993 that limit public access to records or meetings shall remain in force, and such laws apply to records of the legislative and judicial branches until they are repealed. Rules of court that are in effect on the date of the adoption of this section that limit access to records shall remain in effect until they are repealed. History. Added CS for HJR 1729, 863, 2035, 1992, adopted 1992, amended SJR 1284, 2002, adopted 2002.